Hello, everyone. This is Denise. I have attorney Noreen back with us today, and I'm so excited and so glad that he has returned back to answer some of our questions. So today we're going to ask a few questions that I have been receiving either over the phone or messages and stuff like that, and hopefully he can help shed some light on those questions. So, like I said, we have attorney Noreen. Would you like to say anything before we get started with the questions?
No, I don't think so. I'm happy to be back. For those of you that didn't join last time, again, my name is Douglas Noreen. I'm the managing partner of Howard Stallings, a law firm in Raleigh, North Carolina, and mostly practice in trust, estate, and guardianship administration and litigation. And so happy to be here to answer some questions.
Okay, great. All right. So the first thing that I wanted to ask was about illegitimate children. So I've had people to ask me or say, well, I have siblings, but they're not entitled to anything in the estate because they are illegitimate. So I wanted to find out if that is true. And if it is true, what determines if that child is considered an illegitimate child?
Sure. So, as I did last time, I'll start by saying, although I am an attorney and we'll talk about these issues, this is not specific advice to any specific situation. And certainly, if you have questions about a specific estate or certain specific people, you should consult with an attorney of your own. And of course, happy to take direct calls or emails afterwards if you are looking to retain someone, either me or somebody else. But so these are our general comments and not intended to be legal advice. With regards to illegitimate children, we do get into those issues quite frequently. My personal opinion is that our legitimacy statutes in North Carolina are a little outdated, given kind of today's culture and society and the way things work. But those are the laws, and so that is what we work under. Legitimacy, obviously, for heirs that are driving their benefit through a mother or a grandmother, is generally proven through a birth certificate, and that is relatively straightforward as far as things go. Where we run into issues are proving inheritance rights through a father, being obviously the person that didn't give birth to the child. And so what the law requires is that not only that that the father appear on the birth certificate, but also that the mother and father are married at the time the child is born. And that's why I say I think our statutes are a little outdated. I don't have any data on it, but I would imagine, when those laws were written 50, 100 plus years ago, most children were born to a marriage. Nowadays, it's a little more common to have children born outside of a marriage for whatever reason. And so we just have more of that. And the law still requires the parents to be married in order for the child to inherit. So it's kind of an outdated, again, system in my opinion, but again, it's what we have. After the child is born, if the father and mother are not married, and the father appears on the birth certificate, that is not enough for the child to inherit. There is a procedure to be done after birth, where the father would acknowledge the child as their child, and it would get filed with the clerk of court. Hardly anybody knows about that procedure, and so it's almost never done. I have never seen it done. I'm sure somebody somewhere has done it, but it is, when we get into these cases, usually we're not seeing that. So that usually doesn't exist. The other way to prove paternity is if there's an acknowledgement in anything filed with the court. This we do sometimes see. I don't think it is ever meant this way, but if the parents, say, subsequently get married and then were to divorce, whether there's some sort of child support proceeding, because even if the parents aren't married, there can be child support. And so if there's a child support proceeding and somewhere in that court case, the father signs a document indicating that he is the father or acknowledging that he is the father, we can use that as a signed document submitted with the court to prove that he is the parent. So there, sometimes we can kind of shoehorn in those types of documents to meet the requirements. If that doesn't exist, and I had one of these recently where the father was financially helping the child, but they never went through the court system. They just did it on their own, and the father was supporting the child. And so parents were not married at the time. There was no acknowledgement filed with the clerk, and there was nothing in a court file we could rely on. There was really nothing we could do. The child was not considered to be the child of the father.
Wow.
I will mention there are rare circumstances where it gets nearly impossible post-death. Once the father passes, if none of those things have happened, it is very, very difficult. But there is a procedure where we can use DNA evidence. It has to be filed within the claims period, which is within 3 months, generally, of the estate being opened. So it is a very small, I would almost call it a loophole, that sometimes we can use, but it's kind of a Hail Mary at that point. So we run into those issues a lot. You can plan for them ahead of time, and certainly by doing a will ahead of time. I mean, if a father does a will and says, I want to leave my property to, this child, then it doesn't matter whether they're the child or not, right? Because they have been named in the will, and you don't have to be a child to be named in a will. As people know, you can name a charity, you can name your aunts and uncles, you can name your neighbor, you can name whoever. And so by planning ahead, you can address some of these issues. But if there has been no planning ahead and we have an issue of paternity, it can be difficult.
That is very outdated because, like you said, there's a lot of people that have children out of marriage, and then some that marry later. So if they married later and they really are the biological father, that child is still considered illegitimate.
Correct.
Wow. That's
yeah. I think it's just outdated. That's all there is to it.
But if he had put his name on the birth certificate, so they wasn't married, they was dating, he did put his name on the birth certificate, then the child is not illegitimate.
Still not legitimate. Correct.
It's still not legitimate?
Because name has to be on the birth certificate, and they have to be married at the time.
Oh, wow.
So even if the father puts his name on the birth certificate, and that's one of the issues, frankly, is a lot of people think that's enough. Just without knowing the law, I would think that. I mean, if the name's on the birth certificate, the name's on the birth certificate. As I understand, or what's been explained to me, the issue with that is, and I have children. I don't remember how our birth certificates got filled out, but the issue would be that the birth mother could say, person X is the father, and it gets written on the birth certificate. That may or may not be true. So there's that added level of not only does the name have to be on the birth certificate, but they have to be married. If not, you have to do one of these procedures after the fact. Yeah,
and it seems like that should be something that maybe the hospital or somebody should be telling people, because this is the first time I really heard of this. I always thought that, especially if the father signed the birth certificate, that would be considered a legitimate child. Yeah. So, and I'm pretty sure there's probably a lot of other people who don't know that either.
Yes.
So,
yeah, I agree. I mean, the best thing to do is to write a will, right? If the father writes a will, then all this goes out the window, because you're making that decision about who to leave your property to, whether it be your child, whether it be your spouse, whether, again, aunts, uncles, charity, whatever. You're making that decision. It's when people haven't written a will and it goes to kind of the laws and who's your heirs and who's the next of kin that we get into these issues.
Yeah. I guess, though, there's probably a lot of young fathers out there, and they're not in that mind frame of thinking about, I'm going to create a will. So that's where really the problem comes in. Well, I'm glad you shed light on that because I surely didn't know that. You know, I'm sure a lot of other people didn't know either.
Yeah.
So
Yeah.
okay. All right. Um, so our next question is a question that someone asked in the group not too long ago, and I believe she was saying that in North Carolina, since the heirs, the property is automatically vested to the heirs. How do you show proof, like to the mortgage company, if you want to get your name, or to a refinance company or somebody? But how do you show proof that you are an heir and that the house now belongs to you?
Yeah, so this is an interesting point, and again, kind of a quirky way that North Carolina law works on this point. So, and I'll take a step back for a second because it's pertinent to kind of how I'm about to explain this. The North Carolina law handles personal property and real property, commonly known as real estate, differently after somebody dies. So after somebody dies, their personal property, which those would include things like your vehicle, your clothing, your furniture, your bank accounts, think of kind of your stuff, if you will. That's all personal property. After you die, that becomes owned by your estate. The estate takes possession of it. The estate will administer it, may sell a vehicle to pay a debt, whatever the case may be, and then ultimately disperses it to your heirs after the debts are paid. Real property, in a contrary way, does not ever become owned by the estate upon death. It immediately becomes owned by the heirs. And so, whether, again, that be in a will that heirs are named, whether it be at law, if there's no will and we're just going to next of kin, it immediately becomes owned by those people. So, commonly a spouse or a child or, sorry, let me close my email here so we don't get any more notification. Whoever the heir is, and people don't, again, it's quirky and people don't understand. They would assume the estate would be in charge of the house, but it's not. It goes immediately to the heirs. How you would prove that then, kind of to get to the question here, to a mortgage company or something like that. Generally, when we're looking at title to real estate, people are looking for what's called a chain of title. And so they would look at the past deeds to the property. They would see, depending on how far back they're going, let's say in 1950, person A deeded this property to person B. And then in 1970, it was deeded from B to C. And then in 1990, it was deeded from C to D. And you see that kind of 1, 2, 3, those deeds in order as to how the property was passed. When somebody dies while owning a piece of property, there is not a deed, and obviously they're not here anymore to sign a deed. And so what North Carolina law says is that the estate file itself acts in lieu of a deed. And so a title searcher, if somebody's looking at title, when they do that, they not only look in the register of deeds for all those deeds, but they would look in the court files and the court system to see if there are any estates. And so you may see, a deed in 1970, a deed in 1990, and then an estate in 2000. And that would be the document that would pass the property to the heirs. So when you go to a mortgage company to say, I'm now the owner, again, you're not going to have a deed because there isn't a deed. You would want to get a copy of the estate file, and they may not want the whole thing. They may ask for certain documents out of it. If there's a will, certainly they'd want to see that, so on and so forth. And they'll probably also want to see a death certificate just to kind of have in their file that the person did in fact pass away. That would also be filed in the estate file. So if you got the whole thing, they'd probably handle it. But those are the documents they need is the formal estate file, which acts in lieu of a deed to show who the property owners currently are.
So on the estate file, is that going to list all of the heirs?
Mm-hmm.
Okay, and
that's why they can rely on it, because in the estate file it lists who the heirs are and in what percentages.
Okay, all right, okay, I got you. All right, and then they would just show maybe their proof that they are who the state is saying, like the name.
That's right. That's right. And every candidly, every mortgage company is a little different. Some may want more documentation, some are okay with less. So I think my practical tip is just try to be as communicative with them as possible as to what it is they're looking for and what it is they need. Certainly the bigger banks can be hard to communicate with, just because they're big corporations and it's hard to get somebody on the phone and things like that. So it takes a little work, a little elbow grease, if you will, to work through it. But just try to be in touch, see what it is exactly they need, and get it to them. But it's going to be either some or all of the estate file.
Okay. And that estate file, is that something that's like when the person goes to file probate, is the estate file created then, or is that like an extra step they have to do outside of probate?
No, that's exactly what it is. So when you go file for probate, the estate file gets opened,
Okay.
and that's what it is that they would be wanting to see.
Okay. Okay. Someone in the group asked a question. Do you see it?
I do, and that's kind of the question. If we're ready to move on to your third question that you had provided to me, is really the question that was number 3. So I'm happy to. That's a good timing for that. So if an heir does not want their inheritance, whether that be real estate, whether it be cash, whether it be a vehicle, whatever the case may be. I think your question, Denise, was about real estate. From the comment, I can't tell exactly what the asset is, but the process is the same either way. So I can address it. Anybody can renounce their inheritance. You would simply file in the estate file a renunciation, saying, I do not want this. What happens then is that in the estate file, the court will treat you as if you predeceased the person. So as if when that person passed away, whose estate we're handling, fictitiously, they will treat you as if you were already dead at that point. That does mean generally it's going to go down the line. So if if we have, say, a grandparent, a parent, and a child, kind of a 3-generation family, the grandparent passes and the parent renounces, it's then going to go to the child. It's going to go down the line to the child. So that is certainly possible, and the only twist to that is that if a renunciation is filed within 9 months of death, then there are no tax implications to it. After 9 months, if you file a renunciation, the IRS will treat it as if you accepted the asset. Oh, I'm sorry, hang on one second. The only twist to that. Apologies, I always forget to mute my phone. So after 9 months, if you file renunciation, the IRS is going to treat it as if you accepted the asset and then gifted it away. So it'll potentially require a gift tax return, things like that. Now, I'm getting a little deep down the rabbit hole here. I apologize, but according to today's IRS rules, a gift tax is generally not that much of a concern. The lifetime gift tax exemption is somewhere, it changes every year and it's pegged to inflation. So it's an odd number. It's not a round number, but is somewhere north of $12 million last time I checked, which means you can, during your lifetime, give away $12 million tax-free. For most of us and most folks, that is never going to be an issue. I hope it is for anyone listening here, but for most of us, we don't plan to give away $12 million during our lifetime. So filing a gift tax return, for a piece of property that may be worth, let's say, a couple $100,000, although you have to report it, you're not going to owe any tax on it. Now, that law could always change, of course. That number could be lowered, it could be raised, could disappear. You never know. So, I can't say what will happen in the future. But as far as today, that 9-month deadline, while it's important, it's not likely, if it's missed, to really have any practical impact, other than maybe an additional filing, but there won't be any taxes with the IRS. So So yes, disclaimers can always happen. And then the last comment I'll make on that is, again, if you disclaim, it's going to go down the line. If you don't have any children, if there's nowhere to go down the line to, then it's going to, in essence, it depends on your family tree, but it's going to start either going kind of back up to maybe a surviving parent or out to siblings, whoever your next of kin are going to be in your family tree. If it can't go down into any lineage below you, it'll start either going up or out to other family members.
So if someone doesn't have that knowledge and they gave something away thinking that they could just do it, and later on other family members found out and they did have that knowledge, would they have like grounds to stay on to take the property or whatever it is back from the person that it was given to?
Well, it depends on how it was done. I would say probably not, because if you do it that way, the only way to do it the way I'm describing is to actually file the disclaimer in the estate file. If I inherit a vehicle and I just give it to my friend, then I've accepted it and I've just given it to somewhere else. The rest of the heirs wouldn't, have any way to come back on me to say, well, you shouldn't have given that away. I mean, once it's mine, once I inherit it, I can do whatever I want with it. I mean, I can sell it, I can drive it off a cliff, I can give it to a friend. I mean, it's mine, right? Mm-hmm. So if it's done that way, where somebody just receives an inheritance and gives it to someone else, well, that's their right to do that. If they did file a renunciation, which is kind of formally saying in the file, you're going to treat me as predeceased, and I then tried to give it away to somebody else, I wanted to go to my son John instead of my daughter Jane, but I filed a renunciation, then yes, she would have an issue to say, well, you didn't have the right to give it away because you're being treated as if you weren't even here. And so we could go back. But if somebody just, accepts the inheritance and gives it to their son John, never files a renunciation, that is their right to do so.
Okay. So they have the right to do so. So they don't want it. They have the right to pass it on to somebody else. Mm-hmm. Even though there's other heirs, they don't have to pass it down to them. They can give it away.
Correct. I mean, if they accept it and accept the inheritance and it becomes theirs, then they can do with it what they wish.
Okay. All right. And so did we address her question?
I think so. The question was, mother had a will, one of the sisters is acting out and does not want anything. What needs to happen? So she would file a renunciation. Again, before or after 9 months, may trigger a IRS filing, but not likely to have any practical tax effects. So she would do that, and it would go to the rest of the heirs. Alternatively, again, she could accept the inheritance and then give it to whoever she wanted. My guess is based on that language that a renunciation would probably be the better way to do it, but that may be specific to that situation.
Okay. All right. So moving on. Our next question is, if one of the heirs took a wrong turn in life, they're either on drugs, in prison, have a felony record, do they have any say-so with the probate, and do they have any rights to the inheritance?
Right. So kind of two questions there and I'll take them in order. Do they have any say-so in the probate? Question number one. And then number two, are they entitled to their inheritance? Actually, let me start with number two. Yes, they are entitled to their inheritance. Being a felon, being incarcerated, having drug issues will not cancel or end any inheritance rights. The only exception to that is there is in North Carolina what's called the Slayer statute, meaning that if you were the cause of the death, then you can't inherit. So if there's in essence a murder, right, and I've actually had one of these cases, then that person cannot inherit. They can't benefit financially from the criminal act they did. But as long as the felony isn't that, if it's anything else, then yes, they would inherit. Okay. So that doesn't change anything. The whether they have any say-so in the probate, it does affect that. A felon is not allowed to be the administrator of an estate. They are prohibited from doing that. And so they would not be able to be the personal representative, being the person doing the administration. The court will not appoint them and will be looking for another family member, or if, say, they're the only child, then they'll be looking for, siblings, aunts, uncles, somebody like that, or perhaps the public administrator in the county if nobody's available. But they will not let a felon administer an estate. I'll go back to expanding on that a bit. I mean, as far as are they entitled to an inheritance, if somebody has substance issues or is incarcerated or something like that, commonly the parent or whoever it is that is passing this inheritance down is probably aware of that and may not want them to get outright the inheritance. Somebody who has drug issues probably doesn't need $10, $20, $50,000 in their pocket all at once. And so with some planning ahead of time, and I don't do any planning, if anybody has a question or needs a referral, I can provide it. But, that's a situation where I'd commonly see a trust or something like that, where we're putting someone else in charge of that money, a sibling, an aunt, an uncle, who's going to say they get the inheritance and then can dole out the money as they see fit for that child. So, they may get, let's say, $50,000 to be held in trust. And they'll say to the child, look, if you want to go to rehab, I'll pay for it. I have money set aside for your benefit, but I'm not going to just be giving you cash that you can go buy these, substances or alcohol or whatever the case may be. So with some planning, you can put someone else in charge of the money and try to alleviate some of that. But short of that, somebody having issues is not going to discount them as an heir.
Okay. All right. Now, what about like the paperwork? Because like when somebody filed probate, they have to let all the heirs know, and the heirs have to agree or say they don't agree to this person being the administrator. So I had someone call me. His sister was in prison, and so would she need to sign off on the paperwork?
It depends on the circumstances. My guess is probably not. At least at that stage of the game. So what happens is, again, when somebody has a will, generally they've named who they want to be the personal representative. And if that person's not available, generally they've named a backup. So, we have usually in a will, we have kind of, here's person one. If they can't do it, here's person two. And so we don't get into this issue. If somebody dies without a will, the law says that there is an order of people who are available to administer the estate. It starts with a surviving spouse. They have the first priority, and then children are next. And so I'm kind of reading between the lines on your question that this may have been one where there was multiple children, and again, maybe one is incarcerated. So they all have equal rights. Nobody is higher than the other because they're all children. And so, we could have a situation where multiple children submit applications to the court, and the court either needs to decide between them or appoint multiple people to do it. Usually the court will try to decide between them. Having multiple people do it is cumbersome and can lead to problems. You can imagine having 2 or 3 people agree on everything, sign every document. It just becomes problematic. So the court usually wants one. They're usually looking for one person. And so they will, maybe have a hearing, maybe schedule, say, all right, everybody come to court, tell us why you think you're best, and we'll go from there. In a situation like you've described, maybe somebody's incarcerated, so they're probably not going to submit an application, but they do have the equal right. So usually what will happen, and this depends a little bit on county to county, but this is generally the procedure I've seen, is that when one child submits an application, the court will send notices to the other child or children to say, brother number one or sister number one has filed. If you have any concerns about that, or if you want to file an application, you have 20 or 30 days in which to do it. If she, in this case, again, incarcerated, sounds like sister, doesn't respond to that, just doesn't, she's not going to participate, she's not going to sign anything, she's not going to do anything, then the court will take her non-response as an agreement that the child who applied can move forward. So that will not hold them up. When it comes time for a distribution of the estate, so at the end, when the administrator has finished administering the estate and say there's checks to go to all the heirs, we would need that sister to accept her money on some level. If she, again, totally refuses, will not sign anything, will not participate, then usually we deposit it with the courthouse and tell her, look, you wouldn't accept it. We've left it at the court. You can come get it if you want. The court will hold it, I believe, for 7 years, and then it escheats to the state of North Carolina, and it's no longer there. So there is a way to get around it, and if somebody is going to be unresponsive through the entire process, it adds a hoop or two to jump through, but that's okay. We can get it done.
Okay, all right. And the next question is there a way to speed up the probate process so foreclosure can be avoided? So I've had a few people to call me, and no one in the family had filed probate yet, and they received letters that the house was going to be going into foreclosure. Yeah. And they was concerned because there's, once you turn in the application, you may possibly have to wait 30 or 60 days before they make you the administrator. Yeah. So they wanted to know, was there any way to quicken the process?
This can be a county to county question. Some counties do take quite a long time. Generally, some of the bigger counties, Wake, Mecklenburg, those types of counties. Smaller counties generally, depending on the county, in a lot of counties, you can walk in the front door and walk out with your letters. It can happen that quickly. So my general advice would be to engage the clerk and engage the estate's office personally and as quickly as you can, whether that be by phone, whether it be by walking into their office, and explain to them the situation. Say, this foreclosure is happening. We need to get the estate open right away. And I would not be shocked if it could happen either day of, or they send you home with some paperwork or some homework. And if you can come back with a couple of days with some signed documents and the right documents, they could open it then, or at least within a week or so. That's maybe not going to work as well with some of your bigger counties. Again, Wake, Mecklenburg, even if you walk in, it's unlikely you're going to be seen that day. Your options there are really twofold. Number one would be to walk in and just try it. Really explain the situation, say, I need to see somebody either today or I need an appointment within the next couple of days because we have to get this estate open. And I think you could have some success there. The other thing to do is talk to an attorney. We as attorneys have generally standing appointments with some of the clerks. And so we can usually get things open very quickly if needed because we have that relationship. So that can be a way to expedite the process as well as to get the right people on your team.
Okay, that's good to know. Okay. And then we are to our last question, unless somebody in the group have a question. But the last question says the house automatically passes to the heirs if they do not make the mortgage payments. Will it, one, affect their credit score, and two, can the creditors come after them?
Right. So it's, again, this goes back to kind of that quirky point I was making earlier, that the title to the real estate passes immediately to the heirs at the moment of death. So heirs do own the property that would be foreclosed on. However, the debt, the mortgage on that property remains in the name of the deceased. So, again, let's say John Doe is our deceased and we have children A, B, and C. The debt is still John's debt. It is not transferred to A, B, and C. You're not responsible to pay it if it gets foreclosed or if it goes into default, et cetera, et cetera. It is not going to affect A, B, and C because it's not their debt. Now, it is their property, and the debt acts as a lien against that property. And so property they own has this lien on it. And obviously, if it gets foreclosed on because the debt is not being paid, then they would lose the ownership of the property because it'd be sold in a foreclosure sale. My understanding is that that still is not going to affect a credit score because the credit that is being foreclosed remains John Doe's. Although they're the owner of the house via title, it's not their debt that is being foreclosed on or has gone into default. So, now whether a credit bureau would know you were the owner of the property that got foreclosed on, I don't know. My impression is again that they either don't care if they do know, or it wouldn't affect your credit score anyways. Again, because the debt that's being foreclosed is John Doe's, the deceased. So that is my understanding. I will caveat that by saying I'm no expert in credit bureaus or how they work. It's a bit of a black box maybe for all of us, but I do not believe that it would affect the credit score of the heirs.
Okay. All right. Sound good? Well, that's good to know too. I didn't think it would, because I was thinking like what you said, that it's in the deceased person's name. So
Yeah.
how could it affect
Now,
the
I would tell you this though, for anybody that comes to me with an issue like that, a foreclosure, because the other thing that happens is this: because A, B, and C are the owners of the property gets foreclosed, and let's say, let's say there's some equity in the home. Usually there is, right? Because usually lenders aren't lending 100% of the value of the home anyways. So usually there's some money left over after the foreclosure sale. If the house is worth $100,000 and the mortgage is 25, then when it sells for 100, there's going to be $75,000 left over.
Mm-hmm.
That is going to go to the owners of the house. So A, B, and C, as the owners of the house, would receive the benefit of whatever the equity in the house is after the foreclosure sale. So given that, a foreclosure sale generally is not your best way to get maximum value for your property. And so let's say there's a foreclosure pending or has been filed or something like that. Lenders also, candidly, they don't really want to foreclose, right? It takes a while. They have to hire attorneys. There's costs. They can recoup those costs a lot of times, but it's not their preferred method. If they see a way that the property can be sold and they get their mortgage paid off without having to do a foreclosure, they usually jump at that opportunity. So if we have heirs, again, A, B, and C own this house, it's maybe in a foreclosure is threatened, et cetera, what I would do is call Denise Davis, and I would say, let's sell this property. Let's mark it. Let's put it on MLS. Let's get the top dollar we can, rather than it going through a foreclosure sale. It'll pay the mortgage off, and we all take home more money than if we let it go through a foreclosure process. So that's the way I would do it. The only twist in that I've seen is, of course, we have some properties that have either maybe have gone through multiple generations of ownership, et cetera, and we have 20 owners or 30 owners, cousins and second cousins, and et cetera. Now, usually those properties don't have mortgages on them anymore, because they would have been foreclosed long ago in that scenario. But we can have properties where we have kind of dozens of owners, and it becomes unwieldy. I mean, imagine, Denise, you sending engagement letters or representation agreements to 30 people and trying to get everyone to return them. That can be difficult. So sometimes we're looking at what's called a partition sale, where one person can ask the court to order the property sold, and it just takes that one person to get the property sold. So that is another option. But I would, even though a foreclosure is not going to, I don't believe, would affect your credit score, you're not maximizing your money. And so again, I would say, rather than let it go through the foreclosure, call Denise, get her to be representing you and marketing the property. Tell the lender, we've hired an agent, we're going to sell it. They'll say, great. Usually they'll say, great, you sell it. We don't want to foreclose on it, but if you sell it, we get our mortgage paid. you guys go sell it, get your top dollar, and everybody wins.
Mhm. So let me just back up for a second. So if somebody files the petition to partition, only one signature. They don't. So if there's 15 heirs, everybody doesn't have to sign. Just that one person.
Just takes one.
Oh wow. Okay.
Yeah.
Okay. All right.
Yeah, partition can be a useful tool. I mean, basically, in essence, North Carolina law does not, if anyone co-owns property, whether they own 1% or 99% or somewhere in between, if they own any percentage of it, North Carolina law does not require them to continue in that co-ownership and gives them this partition option to get out of it. You can cash out at any time. And all it takes is one. So if we have a 1% owner that wants to partition and 99 other people that own the 99 other percent that don't, unfortunately, too bad for the 99%. All it takes is one. And that person would ask court to sell the property and give everyone their percentage in the revenue, and it'll be done. There is no defense to it.
Now, if the family agrees to just buy that person out, does that stop the petition, or do they
It
still?
would, yeah, because then they're no longer a co-owner. So if the family buys out the one, and that person agrees to that and accepts however much for their ownership interest, then yes, that would end the partition.
Okay. I see a few comments have popped up. Do you have time?
Yeah, let's read these real quick. Okay, so my brother won't leave my mom's house, so I can sell it. What can I do? He's not paying rent, living for free. Mom passed 2020, it's paid off. I'm the executor. Okay, so I'm gonna assume a couple of things about this question, but whoever this user is, feel free to correct me or pop in with some additional details. I assume that the house was inherited by the children, and I understand maybe it's you and him, and I don't know if there's other children or not. That doesn't matter. So whoever the children are, again, whether it be two or more, seems like it's at least two. You guys all co-own the property together, and so he has the right to be there. Seems like there's three children, so the three of you own the house in equal thirds. You all have the right to be there, and so if he is living there, that is something that he can do. It is not owned by the estate. I know you mentioned here you're the executor. For purposes of the property, the real estate, that's not relevant because, as I said, it's owned by the three of you outright. So then we get in this situation, kind of like Denise, you and I were just talking about, of what do we do when somebody wants to sell but other people don't? And really our only option is a partition sale, where one of you or two of you, if two of the three agree, to go ask the court to sell the property and disperse the proceeds. So that is your ultimate remedy, because he is allowed to be there as an owner, whether it sounds like maybe a third, but whatever his percentage is, he's allowed to be there. He's not technically allowed to keep you away, because you are also an owner and you also should have the right to be there. But that becomes one of those practical issues of, if it's that bad of a relationship and that bad of a situation, why would you want to be there anyways? So I would not encourage you to go knock on the door and say, let me in because I'm an owner. That is not going to lead to anywhere productive. But you could get the property sold and he's going to have to leave pursuant to the sale of the property. That is what it is. Does he have to pay anything? A bit of a gray area. I mean, again, as a co-owner, he's allowed to be there. As a co-owner, you guys are allowed to be there. If he is excluding you and asserting sole control of the house, possibly we could say that he is refusing to allow you the rights you have as owners, and that he needs to pay you some sort of rental amount, et cetera, et cetera. It's one of those issues that, depending on the property and how long this has been going on, I understand you say your mom passed in 2020, so it sounds like it's been a few years. I don't know that it would be worth, we'd have to sue him to get rent or get him to pay. And I just don't know that the amount we would recover would potentially be worth the cost of that type of a lawsuit. It's also not, and I see your question there. I'll address that in a sec. It's also not a long-term solution, right? I mean, if we sue him for rent and we win and we get 3 years worth of rent paid to us, he's still living in the house. And so we haven't fixed that problem. We're probably setting up another lawsuit in another year or two for more rent, and it just would be a never-ending cycle. So I wouldn't recommend that, both because I don't know that it'd be financially feasible, but also because it's not really a solution. I think your solution is file for partition, get the house sold. That would get him out, and then you can move forward. For your question, you said I have a realtor that wants to sell the house but can't get in to show the house. I mean, candidly, if we want to list this property with this realtor, he's going to have to sign that. He's an owner. If we want to accept an offer on the property, he's going to have to sign that. He's an owner. When we go to closing and we need to sign a deed, he's going to have to sign that. He's an owner. So is he going to do that? I mean, it sounds like from your comments that you can't talk to him. He won't let you in the house. He's not, doesn't sound to me like he's going to sign anything that we put in front of him. So even if we could get this realtor in the house to potentially show it, are we actually going to be able to sell it if that's his attitude? And so that again reverts me back to partition is the way that one or two of you can force a sale, even if he doesn't agree. Now, I will also say oftentimes when we move for partition, the court appoints somebody called a commissioner to sell the property. And a lot of times that commissioner will hire a real estate agent. So, Denise or somebody like her could still be involved in staging the house and showing the house and listing the house properly. And most commissioners, when they get appointed, if we go to them and say, we've already been talking to a real estate agent, we have somebody we'd like to use, while ultimately it is their call as to who they would use, they're usually receptive to somebody the family is suggesting. So that, that's out there as well. Okay, another question here. Mother-in-law passed earlier this month, died intestate. Sister-in-law is living in the house. A lot of debt, live in New Jersey. My mother lived in North Carolina. I want to apply for administrator in North Carolina, but want you to appoint someone who lives in North Carolina to go to court. Is there any way I can get the court to do a Zoom hearing? So, okay. Couple of questions arise when I read that. I mean, first of all, mother-in-law, I don't, mother-in-law, I mean, if it's a mother-in-law in an intestate estate without knowing the family tree, I'd say it's unlikely you're an heir, because this is not your blood relative to inherit from. So, right off the bat, I'm not sure you would have any involvement in the estate, but potentially, that is based on the family tree. Can you get a Zoom hearing? Those are becoming more common, and certainly in some of the bigger counties, again, Wake, Mecklenburg. Your husband. Okay. All right. So it'd be your husband, who would be the blood relative. Gotcha. That is becoming more common in some of the bigger counties. Some of the smaller counties still are not doing that. We were out west recently and requested one, and they said they wouldn't. So that can be potentially a challenge. And likely what I would be thinking about is if you want to do that, either you'd have to be traveling here from time to time or get an attorney to go for you, which will have a little cost to it, but obviously there's cost to travel as well. So it may be kind of similar cost, but you don't have to take the time to come down here if you can get somebody to go for you. So I'd be thinking about that. You're probably going to get into the issue, as we were talking about earlier, of again, sister-in-law and your husband are both children. And so they are both going to have the right to apply to administer the estate, and the court is going to have to decide who. And so, that may be an issue that gets put in front of the court for a decision. So yeah, hopefully that answers your question.
And I had someone that her and her sister, I guess they didn't get along. So the court actually appointed a lawyer. So they wouldn't let either one of them be it. They appointed a lawyer to do everything.
Yeah, that happens. So if the court just sees there's enough conflict that no matter who they appoint, the other side is going to be unhappy. Um, they will sometimes say, well, we're not going to have anybody in the family do it. We're going to appoint what's called a public administrator. Every county has a public administrator. It's usually an attorney. I have gotten into some counties where it maybe is a local accountant, because it can accountant can usually fill that role. But yes, they'll just appoint somebody independent. And I'll candidly, in a lot of counties, they're very good. Usually I tell clients it is not the end of the world to have the public administrator appointed. They will do this kind of by the book without any emotion. We don't need to worry they're on anybody's side. We just know it'll be done properly. They do take a fee for their work, and it's generally a percentage of what the estate is. So, I mean, there is some cost to that, but it is not a bad outcome generally to have a public administrator appointed.
And I was just wondering because I've talked to a lot of people that kind of sounded like they needed the petition to partition.
Mm-hmm.
Is that a fee charged by the courthouse, or like, do you know kind of an idea of how much that costs to
cost? Yeah. So the commissioner takes a percentage of the sale. So they get paid out of the sale proceeds. Real estate agent, again, typically gets paid out of the sale. So usually there's not upfront cost for the client if you're looking at that, but it does come off the top. So ultimately what you'll get from the sales price is reduced by those costs.
I mean, to file the petition to partition.
Yeah, if you want to hire an attorney, we do a lot of partition work. There are other attorneys that do as well. And we just charge our hourly fee to work on those cases. It's usually not a super expensive process. I would say an easy partition for us is usually no more than $5,000. It does require 2 hearings, so there is some work to it. But if it's relatively straightforward, it's usually not too expensive. If we get into arguments where the cost can increase is if we get into arguments about so in a partition, if, for instance, somebody has been paying the property taxes for 5 years and they only owned a third, but they paid all the property taxes, they can come to court afterwards and say, I want my third, but I also want reimbursement from my sibling shares because I've been paying all the property taxes. Or you can get into a situation, the one we were just talking about, where somebody's living in the home and we partition and we say, well, their share should be reduced because they should have, in essence, been paying us rent. And so we want our share bumped up some. Those are the arguments that can start getting a little bit expensive if we see those. I will also say attorney's fees in a partition also usually come off the top of the sales price. So they are charged to, in essence, everyone. And usually the person filing the partition doesn't bear the sole brunt of what the attorney's fees are. So that can be good as well. You kind of, in essence, are making everyone share in that burden.
Okay. All right. Well, I believe we are to the end of our questions, and I don't want to hold you too long. I have Attorney Noreen's phone number there. So if anybody would like to schedule a consultation with him, feel free to call. Someone just asked another question, but anyway, feel free to call him and schedule a consultation. He is a wonderful attorney. I have referred many people to him and I have a lot of confidence in him. So I just want to thank you for coming on again today, and I hope you'll be back again in the near future where we can answer some more probate questions.
Sure. Always happy to do it. And if anybody, somebody says they can't see the number, so I'll just say it here. If anybody wants to give me a call, phone number is 919-821-7700. So feel free to call me there. That's our office number, so you'll need to ask for me, Douglas Noreen, but happy to answer any questions. Denise, thanks to you for having me. I can say similar nice things about Denise. She has been wonderful to communicate with. Obviously knows her stuff when it comes to the intersection of probate and real estate. And so for anybody who's looking for a real estate agent to deal with kind of heir property or something that's coming through an estate, I would certainly recommend you reach out to Denise, and she can help you.
Thank you. Thank you very much. Okay, well, we're going to end it right here. I hope everybody have a great, blessed day, and we will see y'all in the next live.